can see us okay. So whilst the webinar has been marketed as an IRHP type seminar, the issues covered will be relevant to all claims where there are consequential losses. Okay, so in terms of a brief agenda, I'll be providing an brief update on the IRHP review process, followed by some background to consequential loss issues, issues over causation, evidential requirements, and I'll also run through a few of the cases that I've been involved in. Craig McAdam, who sat next to me, will comment on the law surrounding consequential loss claims. He'll give an update on some recent cases, discuss loss of chance claims, and also will be chipping in and when required. Now, the plan is for the webinar to last for 50 minutes with a 10-minute question and answer session at the end. Hopefully, you'll all have a chat box on the screen, so please feel free to ask any questions and we will try and answer them. And if there are any questions that require some thinking time or research, we will do our best to get back to you as soon as we can. If anybody is having any technical difficulties or can't hear us properly or see the presentation, it will be recorded, and providing I can work the technology, I do plan to put it on the website after, so it will be available to view afterwards. So before we start, just to give you a quick introduction to me, I'm Rob Miller, and I'm a director of Inquesta. We're forensic accountants and insolvency practitioners. I'm a chartered accountant and I've specialised in forensic accounting for over 10 years now. In the last couple of years, the last few years, I've drafted well over 50 consequential loss reports for both the FCA IRHP review process and also for litigation. And my reports have helped claimants obtain redress of well over £40 million. I also assist claimants to obtain litigation funding and ATE insurance. Craig, who sat next to me, is a partner at Slater and Gordon. Craig.
Morning. Yes, I'm Craig McAdam. I'm a lawyer at Slater and Gordon. I head up the dispute resolution team there, and we've been involved in hundreds of claims in the FCA IRHP review scheme for customers of banks. My specialism is in financial litigation, and my role today will be to chip in and assist Rob at points of interest through the course of the presentation. Thanks, Rob.
So, just at the outset, I thought it would be useful to provide a brief update on the FCA statistics in relation to consequential loss claims. Many of you will have seen these figures as they were last updated in September last year. Nevertheless, I thought it would still be quite useful to highlight them now. As you can see from the figures, there have been 3,742 assessments completed, and you'll see from the pie chart that only 1.6% of that population have received redress of over £100,000. Now, that equates to around about 59 people. You'll also see, or you may not see actually, at the top of that pie chart, there is a tiny sliver representing 0.2% of the population. And that's 0.2% who've received over £1 million. Now, I know from my own experience that there is at least one case in there where over £1 million has been, redress has been provided, but this has been offset against the outstanding debt and insolvency. So in actual fact, the business hasn't received a penny of it. So that really is a very small number, and I believe that there are hundreds, if not thousands, of people out there who are disappointed with the outcome of the review process, and who are also looking for a feasible way to litigate. Craig.
Yes, so the outcomes look disappointing on that pie chart. The aim of the review process was to put people back in a position they would have been in had they sustained no wrong in the first place. And the the banks were to apply the usual legal principles. Now, in order to claim for damages, you must show that the bank or the defendant is liable for those damages in the first place. And liability can be formed through a breach of duty, a breach of statutory duty, breach of information duty. And once you've formed that liability, you can then show that the damage which has been caused as a result of that breach. Now, for many customers, the breach was the selling of an interest rate hedge product. Although this seminar hopefully is also useful to people who are involved in the GRG review complaints process and involved in litigation as well. Now, so for many customers, they'll now be out of time to bring a claim for the sale of the IRHP or the trade of the IRHP. And that claim would probably be in negligence, information duties, breach of statutory duties, or misrepresentation, for which you would have 6 years from the date of the breach to bring a claim. So there's some cases which are looking at more inventive claims involving the way the bank treated customers within the review process. So one of those claims is termed the shoreline type claim, which is a claim that the bank breached its duty to customers through the review process. So the claim runs along the lines of the bank had a duty to review the sale in line with the agreement with the FCA, and it thereafter had a duty to assess consequential loss claims in line with the usual legal principles. And they breached that duty in many cases, which is shown by this pie chart, by not assessing them in line with the usual legal principles. Now, it's had mixed reception by courts. 3 cases have now been joined which are dealing with that type of claim, and that they're going to be heard in the Court of Appeal in June of this year. There's another type of claim which again provides a chink of light for those customers who are out of time for the original mis-selling, which is that the banks have breached their contractual duties to their customers in the review process. So as a customer of the bank, you may recall that there was an initial redress for the sales process, and that redress gave customers back the money that they lost in the cash flows for the swap itself. The customer then signed a settlement agreement or an offer letter, and that offer said that in return for you not bringing any more claims in relation to the sale, we will assess your consequential loss claim in line with the usual legal principles. So for any contract to be formed, you need an offer, an acceptance, and consideration. So the letter that was signed was termed an offer letter. The customer is said to have accepted it, and the consideration on behalf of the customer is that it wouldn't bring any further claims in relation to the original sale, and the consideration by the bank is that they'll assess in line with the usual legal principles. And the claim is that the bank has breached that contractual relationship by not assessing it in line with the usual legal principles. But again, that claim in the first instance hasn't been incredibly successful, but is listed for appeal. So there's some claims here which, if successful in the Court of Appeal, would open up litigation for a large number of customers who, looking at this pie chart, haven't had the results that they expected or perhaps should have had in the review process. For the remainder of this seminar, we're looking at damages on the assumption that liability is proven, but that's a big if, and we'll come back to liability again through the course of the seminar.
Okay, so as a starter, just to give you a brief introduction into actually what are consequential losses, and I'll try and keep this as brief as possible, since most of you will be aware of this. So the FCA have defined consequential losses as the cost of being deprived of money. So sorts of examples are loss of business, pressure to sell property, inability to purchase stock, for example. And the business may have missed out on opportunities as a result of not having the money. No doubt these issues will ring true with a number of people who are on this seminar. Another definition is damages that you can prove occurred because of the failure of one party to meet a contractual obligation. Now, as well as the the financial elements of consequential losses, there are also a number of overriding legal principles that need to be considered. Craig?
Yes, so as you said, the legal principle is to put the parties back in the position they would have been in had the breach not occurred. And the courts have developed a two-stage test to that. The first stage would be the but-for stage. So, but for the breach itself, where would the party that's claiming the damages be, and what's been the loss as a result of that breach? The second stage is the foreseeability test, and it's what losses could have been foreseen by the party breaching their duty. The extent of the loss doesn't have to be foreseeable; it's the type of loss which is foreseeable. Now that's the case in statutory duty claims, in negligence claims, and information duty claims. You'd have to show both the causation, the but-for test, and the foreseeability, that the loss was foreseeable by the breaching party. After that, you then look at the remoteness, whether there's things that have intervened in those losses, and we'll come on to that later in the seminar.
And just to give you some examples of the types of losses that you might be looking to claim, the two most common types of consequential loss which I'm asked to deal with tend to be loss of income and profits and loss of capital value. And my work tends to involve forecasting what the trade of the business would have been but for the breach. And to do this, I'd typically look at the past trends, and I'd also look at business plans in place or any specific planned areas of growth. Loss of profits can arise for a whole host of reasons. So, for example, an inability to grow the business due to cash flow constraints, or an inability to raise finance because of a contingent liability on the swap, for example. Loss of profits also can arise from such things as an inability to meet the obligations of a contract, and can often be as extreme as a complete failure of the business. So this is where the capital value fits in. If a business has been lost forever, then I would typically calculate a loss of profits, and then I would calculate the value of the business at the current time. Other types of losses include bank charges, tax payable as a result of receiving damages in a lump sum, and professional fees. And if the case is being litigated through the courts, the legal fees and experts' fees tend to be made by an order from the courts at the end of the matter. So now moving into the crux of this webinar. The idea here is to try and help you to put together a claim that gives it the best chance of success. Now, I'm not here to sugarcoat the issue at all. Consequential loss claims are very hard to prove. A lot of the time, the losses are based on some level of speculation somewhere, and it's very rare that a claimant will be paid the full value of the losses it thinks it has incurred. So I've come up with a concept which I always try and keep in the back of my mind when I'm putting together a consequential loss claim. I've called it the 4 R's. In my opinion, every claim needs to be realistic, it needs to be relevant, it needs to be robust, and not too remote. What I mean by this is realistic is where the claim has to be based on reality, not some form of fantasy that is unlikely to have ever really happened. Robust, I mean it needs to be supported by strong evidence, and relevant, it must be relevant to the business, not something that's totally different from the historic trade of the business. And finally, not too remote, which I'll discuss in a bit more detail as the webinar progresses. Now, whilst many claimants and solicitors ask me to put together a claim and put everything in it and throw the proverbial kitchen sink at it, my personal view is that's not always the best course of action, as it really only serves to increase the cost and prolong the litigation, which doesn't really help anybody. Not only that, but it can actually put the expert's accountant's credibility into question. So if I'm asked to put together a claim which I don't believe in 100%, if it was to go to court and I have to give expert evidence on that, then I can become unstuck. So I think if you can keep the 4 R's in the back of your mind at all times when putting together a consequential loss claim, it will give the claim the best chance of success. So moving on to some of the specifics, in this slide we talk about remoteness. What I've done is I've put together a typical story that may be told to me. So just running through this story, on the first step of the flowchart, you'll see that bank takes money from a business. Well, that's clearly direct losses and more than likely is recoverable. But as a result of that, cash flow issues mean that the bank has forced the business to sell properties. Let's assume it's a property business. The bank's forced the business to sell the properties to repay debt. And as a result of losing that business, the shareholder's other trading business fails because that shareholder has been unable to contribute any additional funds into that business. Thereafter, that shareholder becomes bankrupt. He loses his house. He builds up poor credit and credit card bills. And then the icing on the cake is that a land development that he had, which was a quarter of the way complete, he then has to essentially throw it away because there's no money to finish it. And that results in a significant loss to him personally. So at what point do those losses become too remote?
And that's a difficult question to answer. Obviously this flowchart shows that the losses become more remote, so the losses being claimed are more distant from the action as the flowchart progresses. Now the courts probably wouldn't accept this, but there's a sort of feeling on claims for consequential losses is what should the defendants be liable for, what ought they to pay. So obviously we've talked about the causation, we've talked about foreseeability, and now we're talking about remoteness. And remoteness is a sort of ambiguous concept as to, well, should the defendant be liable for these losses being claimed? And there's there's case law which helps us to determine that. But if we work through the flowchart, the types of losses which are loss of profits or loss of ability to develop a new project would be loss of chance type claims. And the court would look at what's on the balance of probabilities, what's the likelihood of that project and those profits being claimed. So they'll do it on a percentage basis. Now, in some instances, that will depend on third parties. So third parties such as, could planning permission have been obtained? Could extra funding have been obtained? Would extra contracts have been signed by suppliers? And those, again, the court would look at, well, what's the percentage chance, what's the likelihood of those third parties performing their side of the bargain in order for those profits to have been gained? And if the likelihood is less and less, then that could be said to be too remote. Now, as we move through the diagram, we get to shareholders' claims. So the shareholder of a trading business loses house and goes bankrupt, which is the fourth box there. Now, a shareholder who would have a claim against, wouldn't necessarily, have a claim against the bank itself, because its loss is a loss of assets in the company for which it held shares. So the assets been lost. The company itself has been the victim of that loss. So the shareholder has what's termed a reflexive loss. And reflexive losses aren't claimable, or the principle that they're not in general. So the company A would have the claim against the bank. The shareholder itself wouldn't have a claim against the bank because it's too remote. Now that's a general rule in litigation. If we look at the GRG review scheme, that's looking at principles that the bank may have breached in relation to its customers. So if the bank was treating company A and the director and shareholder of that company as one customer, then it could be that a claim could be made for the losses suffered by the shareholder, the customer, as well as the company within that review. At the moment, we don't know how the bank are going to assess complaints in the GRG review process. But I don't think, looking at the way that the information they've published, that in certain circumstances that sort of claim isn't a realistic complaint to be making.
So Craig, what about the actual shareholder of that business who wants to make a claim personally, given he's not actually signed the contract for the swap? Can he make that claim?
Well, no, so that would be a reflexive loss. So his losses would be, the losses would have been sustained by the company, not by the shareholder.
Oh, okay. Okay, so the next slide is named causation, causation, causation. It is a particular bugbear of mine, and is often ignored by people. Many people do think this is a legal matter, but more often than not, or quite often, it does fall on the evidence of a forensic accountant. I'm often asked by clients to just calculate the losses because they want to know what the value of their claim is, but not necessarily look at causation. I take the view that actually the losses are secondary, since without proving that the losses were caused as a direct result of the breach, the claim is really unlikely to go anywhere. So taking an IRHP claim as an example, the sorts of questions you should be asking yourselves are, well, did the IRHP cause the loss? Did the contingent liability arising from the swap cause the loss? Did the bank increase pressure on the company as a result of the swap? Could the company have avoided insolvency but for the swap? And another question is, did you mitigate your loss? Mitigation is a very important point, which is often missed by claimants. Craig, can you provide some more information on mitigation?
There is a duty to mitigate, so a claimant has a duty to keep their losses to the minimum that they can be. So, an easy example of that could be a company which has two bank accounts, bank account A and bank account B. And in bank account A, they've got £200,000, which they lose through cash flows to the bank, putting them into the overdraft and suffering increased interest and fees as a result of that. Now, if they have in account B, £1 million, and they decide not to transfer that to get to the account A back in above the overdraft, then they haven't mitigated their losses, and it'd be hard then to claim for the losses associated with account A.
So a good example of this, and an example I've seen on a case, is where the shareholder or director has actually contributed. Let's assume that they've paid out £100,000 on the hedging product, but at around the same time, the director has contributed £100,000 into the business. So in effect, what they've done is they've mitigated their losses arising from the IRHP. And in those circumstances, the loss will be limited to the interest on the money that was introduced. Now, as we've said already, all these cases are very fact specific. So if the business can prove that that money would have been introduced anyway and had always been planned to be introduced into the business, then clearly there is still a loss. And this is another important point to make, is that you've got to show that it was the breach and the breach alone, whatever that might be, that caused the loss. So I've seen many swap cases where the business was actually in difficulty before the swap payments hit, and that could be because of economic factors, particularly around the 2007-2008 time, that the economy was in a mess. So whilst the swap may have been the straw that broke the camel's back, it can be very difficult to prove that it was just the swap that caused the loss. Now, this is where the RBS GRG review and also the recent HBOS fraud can become quite useful. So I've seen a number of cases where the company has been placed into GRG, and often one of the reasons for being placed into GRG is because there is a swap. But it's proving that the business was put into GRG because of the swap. But if you can prove that the two together work in tandem, then it does actually make the claim slightly easier. Another question that I'm often asked and is constantly up for debate is, what date should the losses be calculated to? Many people, many barristers and solicitors say that it should be calculated up to the date of the breach. My personal view is, unless there are specific reasons why not, so for example, if the business had a plan that had a planned exit strategy, other than that, I would say the losses should be calculated to the current date or the date of a notional trial. So by way of example, taking a property which has always held the property long term, has never really sold any property, but it's been forced to sell the properties by the bank. It seems to me that in that situation, the only scenario that could be foreseen by both the bank and the claimant was that the claimant would still have those properties, but for the breach. So on that basis, I'd be looking to calculate the loss of rental profits, but for the breach up to the current date, and I would then calculate the capital value of the properties now. I'm also asked how debt fits into these sorts of claims. And again, to me, it's fairly simple, and it depends on the specific circumstances of the case. But if there's not been any, if if there's been no debt forgiveness or anything like that, and the debt is the same as it was, in my view, the debt's irrelevant. And I say this on the basis that the debt is repayable regardless, both in the actual scenario and the but-for scenario. What it does affect, obviously, is the amount that you'll receive at the end of the claim. Obviously, the debt is still repayable even if you win the claim and receive money. And what about future profits? Future losses. Future losses are inherently difficult to calculate because they involve some level of speculation. Now, I have many clients who say to me that the capital value of the properties or the capital value of the business is far lower than the amount that they would have actually earned had they received the money, let's say, over a 20-year period up to date of retirement, as an example. So, as I say, as an example, property company receives rental profits of £100,000 a year. The owner of the business plans to retire in 20 years' time. In his mind, he's lost £2 million. Not only that, he's also lost the capital value of those properties in 20 years' time at the time when he wishes to sell them. Now, property and businesses tend to be valued on a capitalised earnings type basis. So in the property, the commercial property would be calculated on the basis of a yield, and a trading company would normally be calculated on the basis of a multiple of earnings. Claimants don't tend to like this because, as I say, they see that this is going to be significantly lower than what they believe they will achieve. And whilst this may be true, it's very important to consider factors such as the time value of money, the risk of death, or the risk of the business failing, and also just the general speculative nature of future profits. Nobody has a crystal ball and can tell what's going to happen in the future. So even on this basis, even if you were to calculate the earnings over that 20-year period, they would have to be heavily discounted to take into account these factors. And this is ultimately what the multiple is supposed to do. It's supposed to be a discounted, capitalized value of the future profits of the business. Now, hopefully, in a recent opinion that was provided on a case that I was involved in by a QC, he commented on the basis that I'd calculated the losses. Now, I calculated the losses to the date of the report, as I said earlier, and this barrister says that the loss has been calculated in the Inquesta report on the basis of the difference between the capital value at the date the report was drafted and the sale price achieved. He goes on to say further on that this seems to me an appropriate approach to calculating the loss, and an approach a court is likely to adopt. Now, so far I've said every aspect that we've commented on is the most important part of a claim, but really and truly, evidence is the most important part of a claim, because without it, the claim is unlikely to go anywhere. There are many different types of evidence. Each will hold a different weight in court. The best form of evidence is contemporaneous, original documentation. Craig, can you provide some further information on this?
Yes, as Rob said, evidence is the most important. The burden of proof is on the claimant to show what losses have been caused by the breach of the defendant. So the types of evidence that will be considered are contemporaneous evidence, so original documentation created at the time of the breach, and then there's all the way up to recollection evidence, which is by way of witness statement. So if we talk about liability, at the time that a trade or the behaviour of the banks took place, the banks, every time they come and speak to you or send a letter, is recorded in their back office systems. So that forms a contemporaneous note of what was said and done. Now, that may be in dispute, or the interpretation of what was said and done may be in dispute by the customer. But unless the customer's got a contemporaneous note, their evidence is always going to be recollection evidence after the event. Now, when a judge is asked to consider these two pieces of evidence, greater weight is almost always going to be given to the contemporaneous evidence rather than recollection evidence, unless there's very good reason why there shouldn't be. Other forms of evidence will be correspondence. So you have the contemporaneous notes of a meeting, and then you have the email exchanges, letters, contracts, which are flowing back and forth from the customer to the bank. So again, that's very good evidence to collate together. And of course, then you have the recollection evidence as well. And you also have evidence which perhaps doesn't involve the defendants, the bank, because this is correspondence that you've had with the planning department or with the valuer or a surveyor. If there's business plans that have been formed by the company and those have been communicated with the bank, then again that's very good evidence as to what the intention of the business was. That's going to assist with the foreseeability argument. So the more of that evidence that you can get together, the more helpful it's going to be. And before you can consider whether you have a claim or a complaint with merits in the GIG review, then you need to assess what evidence you have, and whether that's a request to the bank in advance of making a complaint for evidence, or whether that's collating everything you have on email or in the office together. Then that's your starting point. The next slide deals with misrepresentation. So at the moment we've dealt with damages that flow from breaches of liability, whether that's statutory liability or statutory duties or common law duties. If you've got a claim for misrepresentation, then the need to show foreseeability falls away. And a misrepresentation can be a negligent misrepresentation, or it can be a dishonest representation, a fraudulent representation. But either of those, you just have to show the damage flowed was caused by that representation. The degree of foreseeability falls away from that claim. So in some respects, having a misrepresentation claim makes a claim for damages easier.
Okay. So this really finishes the substantive part of the webinar, and what I'd like to do now is I've got 3 case studies which I'd like to talk through, each with slightly different aspects which help show how to model a claim to give it the best chance of success. So in this first example, and just another thing to add now, that once we've done the case studies, we will be having the question and answer session. So if you do want to, I can see a couple of people have already included some questions, but if you want to start typing in any questions into the chat box now, we will do our best to answer them. So this first case study is a property developer that received redress in the review process. It's a swap claim. It was forced to sell properties, and it was forced to split a property into smaller properties which were worth less together than the whole. The consequential loss claim was put into the review, and a small minor offer was made by the bank, which was rejected, and then a full detailed response was submitted. And as a result of that, the claimant received close to £1 million by the bank. So the question is, why was this claim successful in the end? And the reasons that I can see were that the client was really bought into the process. On day one, he came to me with a box of folders, all indexed up, setting out for each head of claim the evidence supporting it. And whilst it may have cost him a little bit more for me to go through every folder, I always prefer to receive everything than have it cherry-picked by either the client or by a solicitor, because many times this leads to unexpected surprises at a later date. And as a result of all this evidence, we were able to deal with the causation of the claim at the outset. So in the first review, whilst the claimant didn't get the full value of his claim, the bank did accept that the losses were to an extent caused by the missold product. They said we just hadn't quite proved the losses. And in the second part of it, we put in a more detailed calculation of the losses and provided evidence to support it. And this is really the evidence side of it, and being brought into the process is a very important part of putting together a consequential loss claim. It must be remembered that I'm, as a forensic accountant, I've not been involved in the business from day one. So just asking me to put together a claim without providing that information makes it very difficult for me, and ultimately makes the claim even more speculative. Do you want to add anything to that?
No, I think you covered everything there. Again, it goes back to the evidence, and the veracity of the evidence is the most important part of any claim.
Okay, so moving on to the next case study. This is a trading company which was classed as sophisticated, so it ended up litigating through the court. And as a result of the mis-sold products, the whole business was lost due to the cash flow and also the contingent liability. It was claimed that because of the swap, but for the swap, the business would have actually still been there and it would have grown at the same rate that it had done previously. In this case, actually settled. It was a satisfactory settlement at mediation. So, in terms of the work I did in that, so we prepared a forecast of the profits that would have been achieved, but for the mis-sold products. And this forecast was supported by historic contemporaneous evidence at the time. Not only that, but we obtained the evidence from an industry expert to support those forecasts. And this is also very important because whilst I'm used to calculating losses for various different companies, where you have a business that's in a specific industry, sometimes you do need that extra support from an industry expert. So I calculated the loss of profit to date, and then I assessed the value of the business at the date of the notional trial. Not only that, but on this occasion I was asked to attend the mediation, and it tends to be some claimants like to be at the mediation, some don't want to pay the extra money for it. And again, I believe that actually this is a very useful thing because I can sit there and number crunch the various different forms of settlement and the feedback given on that day that it was very useful, and I genuinely believe that it helped come to that settlement.
Yeah, I'd just say that with regards to mediation, you have to prepare for mediation the same way as you prepare for a trial. You need to have all your ducks lined up. So having an expert there, or at least having a very detailed report from the expert that you can rely upon, or having them on the end of the phone, is as important in mediation as it would be to have an expert there at trial. And the preparation of going through as much material as you can beforehand in order to present your case as strongly as you can at the start of mediation is very important. Because nobody's going to mediation expecting to either receive or to pay the full amount of the claim, and it's that discount that's provided for risk of litigation throughout the mediation process that's really at stake. So you need to present your claim as strongly as you possibly can in mediation, so that the risks for the defendants are amplified, and that way, hopefully, you get a better result through the mediation process.
Moving on to the final case study, and this is to do with the funding requirements. And as I mentioned earlier, I'm often asked by solicitors to assist in putting together a report to assist the funders. Quite often, the funder not only requires an advice from the barrister, but also an advice on the merits of the claim from a forensic accountant. So in this case, this particular case, the company planned to extend the property but ran out of funds. And they required further finance, and they did have a potential for further finance, but decided not to go ahead in the end. And there was specific contemporaneous evidence from the time where there was an email written to one of the directors, between the directors, where they specifically said that because of the cash flow, they weren't going to go ahead with that funding. Now, in the end, council gave good prospects, but did require some input on quantum and causation. And as a result of all of this together, the case did obtain AT insurance and litigation funding. So again, this just goes to show that the causation point of it is very important, and it's particularly important for a funder to consider the merits of the case. But in addition, where a funder is involved, the value of the claim is also important, so that the funder can work out the structure that it's offering and make sure that the case is economically feasible for all parties. So this is quite a good example of contemporaneous evidence, causation, and also the necessity to put together a value of the claim. So we've actually finished slightly earlier than anticipated, but we do have a number of questions which we will certainly do our best to answer. So the first question that has been put to me is, so what is the best way to assess the hidden cost of the derivatives, for example, the contingent liabilities? Now, I'm not a banking expert, so I don't have the software to calculate those hidden costs. So for me, the best way is to have an industry expert who has the software and can quantify the liabilities arising as a direct result of those swaps. Would you agree with that?
Yeah, I mean, it's a contingent liability, so it's not a loss that's manifested itself, but it's a harm to the company that may have caused further losses. So working out how the credit rating has been affected as a result of the contingent liability is going to be important for, I imagine, many cases that you've looked at. So you know the answer to that is you need to go to a derivative expert in order to get a view as to what the contingent liability would have been at any particular stage in the company's decision making. So if you're saying a particular loss was caused on date X, and it was caused because we couldn't get funding because we didn't have credits and we couldn't go elsewhere, then what was the contingent liability that was stopping you getting that credit? And to find that, the banks probably won't tell you. So you would need to go to a derivative expert, and they should be able to put that into their software and use their knowledge of market predictions to give you an answer to that. And I know Abhishek's online here, so I think he's somebody that might be able to assist you with that.
And then another question is, what about stress? How do you value stress in the consequential loss claims? This is not something that I've ever, as a forensic accountant, that I can get involved in, because how do you actually quantify stress?
Yeah, it's I mean, clearly the actions for the bank have caused stress to a variable degree to a number of people, and what claim can be brought as a result of that. Now, it's quite hard to show that economic loss has caused personal injury, which stress would be. So it's a claim that the bank's actions have caused personal injury. So again, you've got to have the liability ought they to be responsible for that, and was it foreseeable at the time of the breach? So those issues are still important liability questions, and then you have to have the medical evidence to show that that it was this action which caused this personal injury. So they're difficult claims to form. And then what value do you put at it? Well, you then have to turn to the Kemps and work out what value to put at a particular personal injury. So they're not claims that should be dismissed entirely, but they're very difficult claims to bring.
Of course, another issue with the stress angle as well is that where it's a limited company, it's not the individual who is actually contracted with the bank on the swap. So it's not actually the individual who's making the claim; it's the company making the claim.
That's right. Yeah.
Right. Another question. Is the FOS, the Financial Ombudsman Service, supporting customer challenge of any of the bank's poor consequential loss awards? Now, again, I'm not aware of any consequential loss claim that had been paid out through the Financial Ombudsman Service that was rejected in the review process. I don't know about you, Craig.
The Financial Ombudsman Service is there to as a resource if the banks haven't followed the guidance in the complaint process. So they have to follow the DISP rules. If you're not satisfied with the way the bank have handled your complaint, then you can go to the Financial Ombudsman Service. Now, the Financial Ombudsman Service obviously has a limit of £150,000 per claim, so you may not be able to recover everything anyway from the Financial Ombudsman Service. But yes, you can. If you're unsatisfied with the way that the bank have dealt with it, then that is a good organisation to go with. I mean, at the moment, the time frame for getting a determination is anywhere from, I had some back within a matter of weeks, and in other cases it's literally a matter of years. So it's a long process, and again, you need to prepare for that in the same way as you prepare for a trial. So you need to put your best case forward to the Financial Ombudsman. And although they don't follow the usual legal principles, it's much more of an art form. It's your job, or your job of your advisors, to persuade them that one, the bank haven't assessed it properly, and two, that they should be liable for these particular losses. So I mean, I found it to be quite a good resource at times, but it's limited.
Okay. Have you been successful in obtaining any claimant's professional costs of actually producing the CL claim? Well, the answer to this is yes and no, I assume that this question specifically is talking about the FCA review process. So where cases involve Lloyds, Lloyds ask you to put in a quote for the work prior to starting the work, and they will give approval for the fees, and they will pay that money out. Most of the other banks, unfortunately, the answer is no. They take the view based on the FCA that this is supposed to be a straightforward process, and professional fees shouldn't have been required, and the bank would have just reviewed it. I mean, this is a ridiculous stance to take, in my opinion, but unfortunately, most of the banks do stand by it, and haven't paid professional fees out. It's unfortunate.
I think there's. I think for accountants, it's probably more likely that they'd get paid out to some extent, but probably not the whole amount than it would be for lawyers. The FCA made their statement very early on that the whole process didn't require legal assistance. What we found is that between the date of giving the initial review amount and then determining consequential losses, that the banks are open to considering professional fees that have been incurred in putting forward consequential loss claims, but they, very rarely, if ever, pay the full amount. And when you ask them as to how they calculated what they consider to be professional fees that are due, they say it's just a finger in the air type approach. It's what we think is we ought to be liable for, what we think is a fair amount of money to be given to a customer who's incurred professional fees. So there's no real science behind it. And again, you go back to applying the usual legal principles. It's that handbook's out the window when they're taking that approach. So it's a very frustrating approach that the bank are taking. But yes, there's not been a great deal of success in recovering professional fees, especially in the initial stage of proving that the trade was missold. There's slightly more success in recovering professional fees in a consequential loss claim.
Okay, so there's a really good question here, which I think is for you, Craig, and it's to do with if the bank has, providing I've understood it correctly, if the bank has accepted that the products have been missold, it's been an advised sale, and that the product's been torn up, how does that change the claim in litigation?
It'd be unlikely for the bank to admit that it was an advised sale. I mean, I've not heard of the bank ever admitting that they've given advice in a sale. Usually what they say is that we haven't met the standards that the FCA expect of us in this sale, and therefore we're going to pay redress and tear the products up. And again, that's not even admittance of liability or breach of the statutory requirements. They're limiting that admittance to the standards expected of the FCA for the purposes of the review. So if you've got a situation where they say, okay, we've missold this, or I mean, not that they'll use those words, but you're entitled to having your cash flow back, and we're going to tear the swap up or the RHP up, then you still have to bring a claim, and then you're unsatisfied with the consequential loss claim. So you've now decided to litigate. You still have to prove that the bank are liable for those consequential losses, and to prove they're liable, you still have to show that they either breached their common law duties and professional negligence, information duties, statutory duties, or misrepresentation.
Just to stop you there, it seems in this case that this individual has in writing from the bank that it was an advised sale.
Right.
And they have admitted it.
Well, I mean, if they've admitted it's an advised sale and that they're in breach of their duties in giving that advice, then you're just dealing with whether the losses flowed from that breach. So were they caused by that breach, by that negligence advice, and were the losses foreseeable? So you're just then, the issues involved in any litigation will be narrowed down just to those issues. You won't be dealing with liability if the bank have admitted liability. And in fact, I had a case in similar circumstances where the bank wrote to say that yeah, we're not going to be arguing over liability, but we don't agree that the losses were caused or foreseeable.
Okay, moving on. The next question: can you confirm when the best time to involve a forensic accountant when making a claim? This is a great question, and
I'm sure you'll say it
a
early
bit-
stage possible.
yeah, a bit of a bugbear of mine actually, because I mean, I genuinely believe, and I'm not just saying this, I genuinely believe that actually, if you involve a forensic accountant early doors in a claim, it assists in achieving early settlement. It really frustrates me when I'm involved at a later date with the particulars of claim have already been put in, and I end up firefighting, trying to justify figures that I've actually not put together, and trying to deal with causation. And it can happen sometimes where the claim has already been made and it comes to me, and I say, well, actually, I'm not sure you've got a case. There's some problems here with the causation. So I am often asked to assist in putting together the particulars of claim. And this doesn't need to be a belt and braces calculation of losses. This needs to be a relatively robust figure that can be supported at a later date. So again, my view personally involved me earlier. The cost doesn't tend to be any different, and in fact may end up saving money because you may end up getting an earlier settlement. And I'm sure Craig will agree with that.
No, I do. Unfortunately, in sort of dealing with litigation, then we'll deal with the review scheme separately. In litigation, the work is all front-loaded. There's no point in bringing a claim and getting yourself into an adverse cost situation in litigation unless you're confident that your claim has merits and chances of success. So that involves ticking all the boxes, all the hurdles that you need to jump over in any claim. So you need your liability determined, or your drafted out in your particulars of claim as to why the bank are liable, but just as importantly, how they're liable for the particular losses you say that you're claiming for. So if that requires the need of an accountant, and in most cases it probably does, then having an accountant on board before you've issued your claim is crucial. If you're in the IRHP review process and the GRG complaint process, again, there's no point in putting in a complaint that the bank are going to say, I'm sorry, you haven't proven it. So if needing an accountant to prove that claim and show the causative steps, then get it early doors, get it all your ducks lined up before you actually put your complaint in. I don't think there's much point in putting your complaint in, which is then just going to be rejected for you to keep piecemeal putting bits of information in, because your initial complaint is diluted by doing that. You're best having your complaint at its strongest put in one go. And my understanding of the GRG review process is that there isn't a time frame that's been put in place for that. So I've spoken to them and they said, well, there isn't a time frame for you to put your complaint in. So unless anybody knows differently to that, you've got time to get your advice, get your accountants on board, and put your complaint in at the right time.
Okay. Another question here: is there a difference between how an SME is treated and a private individual? Now, I assume this is in the in litigation or any claim.
Well, a private individual would have the benefits of the statutory claim. So if the bank had breached their statutory duties, and that is that if they breached one of the rules in the handbook while dealing in regulated business activity, then an individual has the right under Financial Services and Markets Act to bring a claim, bring cause of action for that breach. And the damage must flow from that particular breach. So if you're picking a particular COPS rule which has been breached, then you have to show that the damage flowed from that particular breach. So an individual has the ability to bring that claim. It's determined in many cases now, but it's still open to challenge, that limited companies don't have the benefit of Section 138 under the Financial Services and Markets Act claim. And they'd need to rely on common law duties, so breach of advice, negligence of advice, information duties or misrepresentation in order to bring that claim.
Okay, so there's a few other questions here which may not be quite as straightforward to answer. The first is in relation to the £10,000 court fee, whether there's any funding available for that, where there's no funds. There's also a question around settlement in mediation as a standard, what sort of percentage can be claimed. Now, taking the second question first, really that's how long is a piece of string. I don't think there's any standard discount that you would expect in mediation, unless you think otherwise. Ultimately, it comes down to really a commercial decision at the date of mediation as to what both parties are willing to accept. In terms of the funding of the 10K,
no, if an individual is bringing a claim and they're able to satisfy the requirements of having the fee waived, then that's an option, but it's not open for companies or even charities, which seems bizarre. I can't remember the exact financial limits that are required, but there's a form that you can print out from HMRC, and there's that you can, if you're an individual and you're on low income or on benefits, then you probably are able to have your fees waived. You can put that application in with your claim form, or you can do it in advance. So it's open for individuals. It's not open for, as far as I'm aware, it's not open for companies or charities.
Okay. Right. Just a last couple of questions that we'll take. So, have you experienced any difficulties with independent reviewers? And the same question for trustees in bankruptcy not pursuing and claiming or releasing a claimant. Well, the second part of that question is an interesting one, and again, a little bit of a bugbear, because my experience so far is that many of the insolvency practitioners aren't. That's not to say all, because there are some out there that will, but many aren't making the claims against the banks for whatever reason. And there are also a number of cases where the original insolvency practitioner has been either it's become a joint appointment, or has been replaced by a inverted commas, a friendly insolvency practitioner who can then make the claim. If this is something that is of interest, then I'm more than happy to discuss that after this webinar. So one final question. How easy is it to litigate only for consequential losses if full basic redress has already been provided? Craig.
Well, I think it's back to one of the earlier questions. It depends on it depends on the bank as well. It depends on what their attitude is, and how they intend to defend the case. So some banks the principle is you'd have to show that the banks are liable for the losses. So you'd have to go back to the first instance and say, this is how the swap was sold to me. This is why the bank are liable for the losses I've incurred. And the banks will say, well, first, they were not liable because, one, we weren't getting advice. Two, we gave sufficient information. Three, you contractually stopped from bringing a claim because you signed this contract to say that it was execution only, and we weren't ever going to give you any advice. Four, you've also signed terms and conditions that say that you're forbade from bringing claims for economic loss or consequential loss, even if we have breached the contract, and the losses that you're claiming weren't caused and weren't foreseeable. So some banks will throw absolutely everything at it. So it's neither here nor there that you've got a determination in the review process. You have to start right from the beginning again. What you can't do is bring a claim for the losses that you've agreed to accept within the review process. So you'll only be dealing with the additional losses. That's already crystallised because you've accepted this, and you may have already signed a settlement offer to that effect. Other banks, however, like we discussed earlier, will say, let's just deal with the consequential losses, let's not deal with the liability. That's probably only likely for private individuals where they they've accepted that perhaps the review process is enough evidence of a breach of the regulatory requirement.
Just going back to something we mentioned earlier as well, there are claims out there where it talks about failure to review the consequential losses in line with the various legal principles. But I'm assuming that although that is a claim that can be made, it's always easier if you can go back to basics and prove the misrepresentation and everything else.
So at the start we talked about the shoreline type claims where the banks were in breach of their duties in conducting the review. and whether that's a common law duty or a contractual duty. If they've given initial redress and your claim is for consequential losses, then you can't reopen the initial redress amount and say that they were in breach of their common law duties or contractual duties in determining that initial redress if you've signed a settlement offer. And I think that's probably got to be right. I mean, there may be other lawyers that disagree with that. But flowing from that, if they haven't assessed your consequential loss properly, the argument is that they've breached their contract if another reasonable body in assessing your consequential loss claim would determine by applying the usual legal principles the bank should have paid out. The argument there is that, well, if that's the case, the bank must have breached the contract, must have breached that settlement offer to the customer by not paying out.
Okay, well, I think we'll call it today there, and I'd like to thank everybody who's attended. If you do need to, if you would like to get in touch with anybody with any, if you'd like to get in touch with either of us if you have any questions, the contact details are here. And also, if you wish to, if you'd like to get a copy of these slides, I'm more than happy to provide that as well. Okay, thank you very much.
Thank you.